Yes,
And the last thing you want to do is talk over me. And you're still being argumentative, even towards me. It just needs to be taken down a notch. Coming at it aggressively might not be the way to do it.
it is discoverable and relevant to the case.
That's it. And that's what I just said. You seem very frustrated, and I'm not sure why.
I'm confused why there's pushback at all.
Well,
That is alarming to me that we would have to even compel anything.
if you'll sit around and watch today how everybody gets along, hold on.
This attorney walked into court like he was the main character, no respect, no greeting, just pure attitude. From the second he opened his mouth, he started accusing the judge of corruption because she wouldn't give him the discovery he wanted. But here's the crazy part, he's completely wrong about the law. Instead of realizing it, he keeps doubling down, arguing louder, and digging himself into a hole. The tension in that courtroom? You could cut it with a knife. By the end, the judge absolutely humbles him in front of everyone, and it's glorious. Let me know in the comments if you think he was really defending his client or just showing off his ego. This one's wild. Let's dive in.
All right, this is cause number 1830854. And sir, you're Juan Sanchez?
Yeah.
And so we're here today on a motion to compel. And before we get into a whole lot, I've done a lot of my own research and looking at all of this. And a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to it at a set time for a hearing. So, under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. But lab results, testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the.
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations of the motion.
May I respond, Your Honor?
Well, let him finish. Yeah.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing.
Mhm.
I have no problem with getting him all that stuff. A lot of it's not in my possession. With the out of county office reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations and they pull to be provided beforehand. And yeah, I don't think he's not entitled to have all that stuff. So
Sure.
I kind of agree.
So-
I don't want to dispute him. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May.
Right.
I don't have anything really responsive to it.
Okay.
This book.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay.
And
I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through.
.222. I've got to pause it right here because this is where things start to explode. The attorney is fuming. He's convinced the judge is hiding evidence from him when in reality, he just doesn't understand the process at all. Discovery doesn't come straight from the judge. It goes through the probation department, then the state, then it's approved and released. That's basic law. But he's not hearing any of it. He's too busy talking over everyone like he runs the courtroom. The tone in his voice? Straight arrogance. Most attorneys know how to disagree respectfully, but this guy's acting like he's schooling the judge on her own job. You can literally see the judge holding back her frustration. And trust me, when she finally decides to respond, he's not ready for it.
But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes,
so
ma'am.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing dates because of conflict.
And Judge, I'd ask Ms. Laveau to go ahead and get everything together today.
Yeah.
To turn over.
I mean, yeah,
There was something that the court was ordering her not.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. Laveau, do you have any concerns you
If there's,
make the court aware of?
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronological.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out though, I think whatever Mr. Nichols, y'all get together, obviously offense report. If y'all have the offense report and you don't even have it, then you need to get, I mean, that's,
Right. I mean,
that's great. Everybody can get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real.
that's what I'm thinking about, but it's not really
Sure.
attorney's notes. And so I don't know that that would be
I
an
would object to
issue.
that, Your Honor, on the grounds it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
That's it. And that's what I just said. You seem very frustrated, and I'm not sure why. I mean, it's, I don't know.
I'm confused by there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
That is alarming to me that you would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial, of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay. So y'all get that done. And then we'll reset the case for just an announcement in what, a couple weeks or so. Fine with that?
That should be fine, Judge. We'll
Okay.
get everything scanned.
Perfect. Thank you. All right. Y'all are all excused. I'm sorry. No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations. Then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good.
Sure.
All right. Thank you, y'all.
Thank you.
That hearing was pure chaos from start to finish. I've seen aggressive lawyers before, but this guy took it to another level. He walked in like he owned the courtroom, threw respect out the window, and got completely embarrassed for it. You'd think someone who studied law would know how discovery works, but nope. He turned it into a personal battle and paid the price. The judge, though? Total class act. Calm, patient, and when the moment was right, she dropped the hammer without even raising her voice. The whole room felt it. Let me know in the comments, did she handle it perfectly, or would you have put him in his place sooner? Either way, this might be one of the most satisfying courtroom takedowns ever caught on camera.